Did you see the response?
I would have served it on feedback on.
Yeah, it's been a little bit.
December 17th. Okay. My certificate of service.
All right, so are you Jonah Johnson?
Okay, right off the bat, we see Mr. Johnson facing a serious charge, aggravated assault with a deadly weapon. That bond is $300,000. This is not a small amount. Fun fact for the audience. Bonds like this are set to ensure the defendant shows up in court, but clearly, it's also about the severity of the alleged crime. Keep an eye on how his attorney is arguing for reduction. It's a critical moment that could change everything for him.
And Mr. Johnson is charged in cause number 25 DCCR 1775 with aggravated assault with a deadly weapon. And Ms. Holmes has filed a motion asking that Mr. Johnson's bond be reduced. It's currently set at $300,000, and then there's also 2 misdemeanors that he has as well. And those bonds, it looks like, are $3,000 and $5,000, which we're not discussing, but just that he has the charges also, in addition to aggravated assault with a deadly weapon, to misdemeanor charge of unlawful carrying a weapon, 2 cases of unlawful carrying a weapon. And so Mr. Coleman filed a response, obviously in opposition to that. Ms. Holmes, Mr. Johnson, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. You may proceed, Ms. Holmes.
Thank you. Mr. Johnson, how long have you been incarcerated at Jefferson County?
Notice how Mr. Johnson is being questioned about his time in jail and family assets. This is a classic bond reduction strategy. Demonstrate responsibility, lack of flight risk, and willingness to comply with restrictions. Audience, think about this. If you were the judge, would having no property of post make you hesitant to reduce bond? Or is showing compliance more important?
Okay, and in the 2 month span, your bond has been set. Is that correct? And has your family tried their best to secure or try to get you bonded out at that amount and have been unsuccessful? Okay, now prior to this, was your bond originally at a different amount and was it raised at some point?
Yes.
Okay, and do you have any property or anything that you could possibly sell to secure where the current bond amount is? Okay, does your family have any type of assets, property that can secure at this amount? Okay, are you requesting that the judge lower the bond to give you an opportunity to bond out, and whatever stipulations the court may have, whether it's a GPS tracker or home confinement, would you be willing to abide by those restrictions?
Yes.
And where would you be residing if you were able to bond out?
I was.
Okay, and where is that, in Beaumont?
Yes.
Okay, and your mom is here today, correct?
Yes.
Okay, and she would be able to let the judge know that that's where you would be residing?
Yes.
Okay, and since you've been incarcerated at the Jefferson County Jail, have you received any write-ups? Okay. At this one, I'll pass the question.
I have no questions for the judge. Just argument.
Okay, so
Here's where it gets technical. The attorney discusses a bond increase due to a GPS violation. These little procedural points often decide outcomes. The court takes judicial notice, basically acknowledging facts without formal proof. For viewers, this is a peek behind the curtain. Bond isn't just about the crime. It's also about past compliance. Every missed GPS payment can cost you dearly in court.
I would, just for the record, I'm taking judicial notice of the court's file. It does include an affidavit of surety surrender. That's where the bond got increased, because the bond's been filed. That affidavit, because it reads that the defendant failed to pay for his GPS device. It had not been charged at that point. So this, it says since 11/7 of 25, and this was filed November 19th. So it hadn't been charged for a couple of weeks, it looks like. They further stated that he will not respond to their attempt to reach him and he cannot be located. Therefore, they felt like their bond was at risk, and that's why they filed that affidavit to get off the bond, which was granted, and that's why that was raised. Give me just a second. I also want to take a look at the probable cause affidavit, just so that I can have an idea of what we're talking about. Mr. Hall?
That probable cause affidavit, I'd like to offer, for the limited purposes of this hearing, the surveillance video from the apartment complex of the incident.
Okay, thank you. Any objection for that for this hearing?
No objection.
I'll take a look at it. Give me just a second when I take a look at this. Mr. Coleman, I'm ready.
Now we hit the dramatic moment. The video surveillance of the shooting. This is where the case gets intense. The attorney even calls it a Wild West shootout in broad daylight. Look at the positioning. The defendant in dark clothing. The bystander caught behind a van. This is crucial evidence. And for our audience, it shows how visuals often speak louder than testimony in criminal cases.
I just want to highlight in my the defendant's he has 9 prior arrests, 2 of which were for unlawfully carrying a weapon. Those cases were pending when he committed the instant offense. Judge, the video, I'll just summarize by saying it's like a Wild West shootout in broad daylight in the apartment complex. Here's the video there. You can just hit play there. Of course.
And what about Kendrick O'Veal? Is he charged as well?
I don't think he got you.
He was the other shooter, according to
he would be the person in the video
PC.
there in the front. It's saying at the front of that red truck. My understanding is that it's the defendant here who's in the background wearing the dark colored clothing.
Okay.
And the bystander who was shot, you'll see her behind like that white van.
Okay.
The younger lady got tampered. I think the one that got shot got tampered.
In that video, it also appears that the first shot, and it's obviously not the best angle, but anyway. The motions.
Bond motion denied. Boom. That's the judge laying down the law. You can almost feel the tension in the room. This is a reminder. No matter how much evidence you present for a reduction, the severity of the crime and prior history often outweighs arguments. Audience, comment below. Would you risk lowering bond in this scenario, knowing his prior arrests?
Denied. You can go back with bailiff. It's crazy. Insane. Nope. You need to go back with the bailiff. Oh, there it is. Sorry, that was... All right. You are Otis Crawford Wilson. And will your client waive the formal reading of the motion?
Yes, Your Honor.
excuse me, Mr. Crawford Wilson, in cause number 20-34521, I have a motion to revoke your community supervision. It shows that you were placed on probation October 21st of 2020 for the third-degree felony offense of escape while arrested or confined, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community services directed. Is that true or not true?
Yes.
True or not true?
True.
Thank you. Count 2 alleges that you failed to pay your court-assessed fees as directed. As of September 22nd, 2025, you were $3,550 behind. And is that true or not true? And then count 3 alleges that you failed to enter and successfully complete the JCDI program as required. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Switching gears to probation revocation, Mr. Crawford Wilson admits to failing community service, missing payments, and not completing his program. 3 strikes in the probation world. Judges take these violations seriously. And here we see a 4-year institutional sentence handed down. For viewers, this is a clear example how compliance, or the lack thereof, can directly affect your freedom. Remember, he also waived his right to appeal, which is significant. No second chances here.
And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablets documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Crawford Wilson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.